Brian said, my name is Morgan Sheppy. I am the attorney for the Child Advocate Program of Pierce County. So what I have put together today, what we're going to run through is, you can probably see on your screen, there's a couple of legislative updates I want to give everybody and a couple of judicial updates. This is spanning the period from approximately last May until currently, so about a year or so. So just as we're doing this by Zoom, obviously, please try and keep your Zoom on mute while we're going. But if you have questions, please let me know, and we can either address them as they come up, or if we get a couple of kind of collective ones, we'll address them together and go from there. My contact information will be at the end of the program, so if you have any questions or you want to talk to me about anything more specifically, you can feel free to reach out to me. And then like Ryan said, you'll get the PowerPoint, the copy of this video as well, and then a copy of all of the cases that I talk about. We'll put those together in case you would like to look at them. So what we're going to be discussing today, basically I've got three kind of topics for you. First, we got a little bit of a legislative update, a couple of bills that passed that are relevant to the work that we do. There's been a couple of changes with the Washington State Supreme Court, so we're going to tell you a little bit about our new justices. And then we're going to take a look at some of the Supreme Court decisions and the appellate court decisions that, again, have to do with dependency with DCYF and the things that we deal with on a regular basis. So we'll go ahead and get started here. By the way, this is probably, I think I've got like an hour and a half blocked off. I'm not going to talk for an hour and a half. It's probably going to be about an hour, but depending on how the discussion goes, we can go a little bit over an hour if we need to. All right, so starting right in with the legislative update. We actually had, I think we had two bills that ended up passing. This one is probably not going to end up going anywhere, but it's House Bill 2525, and that is the Family Connections Program. So this is the bill that develops two pilot programs, one for Eastern Washington, one for Western Washington. And it's intended to encourage in-person meetings between biological parents and foster parents, both when it's safe to do so, and then also when foster parents are in agreement with that. The bill would require a report in September of 2021 to give an update on how this program is working. This also changes various pieces of legislation where it says parent mentors. It would just change the language to be parent allies. So this passed both the House and the Senate, and was actually signed by Governor Inslee mid-March. The catch is that the funding was vetoed for it. So the bill was signed, but there's no funding for it, which means it's probably not going to go anywhere. So we will remain to see what happens with that, but it is something that is, obviously it has support, so we'll see what ends up moving forward from that, that particular piece of legislation. All right, and then the second piece of legislation that passed is Senate Bill 6423. This has to do with reporting child abuse and neglect, and basically what it does is it modifies RCW 2644-03011, and that's the language relating to mandatory reporting. And so you can see, I'm going to go ahead and read that there. That's what the change is. So what it originally said was, I'm sorry, it doesn't change the RCW 2644, it changes the mandatory reporting statute. So except as provided in 2644-03011, upon receipt of a report, previously it said concerning the possible occurrence of child abuse or neglect, and it's been changed to say that upon receipt of a report alleging that child abuse or neglect has occurred, the law enforcement agency of the department, that's CPS, must investigate. Also, it changes the law so that anyone who in good faith makes a report or testifies regarding a report of child abuse shall be immune from any civil or criminal liability. There is a case that we're going to talk about later on today that I think is directly connected to this. I think that the statute changed directly in response to that case. So we'll talk a little bit more about it a little bit further in the presentation. But essentially what this does is, rather than the duty to investigate by DCYF is not triggered by a report concerning a possible occurrence of child abuse, but an actual allegation that child abuse has occurred. So again, we'll get a little bit more into detail about that. So those are the two big pieces of legislation that have passed. Obviously, things got a little bit crazy right around at the end of the legislative session, so there wasn't a lot of reporting out about any of that, but those are the two that are particularly relevant to the work that we do that were passed by the State House, the State Senate, and then signed by the governor. Okay, so a couple of other, moving on to the Supreme Court personnel changes, so now in the judiciary part of things. We have two new Supreme Court justices for the state of Washington. These individuals are both appointed by the governor. So what happened is a justice that is currently on the bench has retired. And so the governor appoints an individual to replace them. They will have to run again when the term comes up in the election, but in the meantime, they are on the bench until the time of that election. So the first justice who is now on the bench is Justice Raquel Montoya Lewis. There's her photograph. She comes to us from Whatcom County up in Bellingham, Whatcom County Superior Court. She was on the bench up there. She previously served as a judge in the Lummi Nation, the Nooksack Indian Tribe, and the Upper Skagit Indian Tribe. I'm not sure if all of those were at once, but she's been really heavily involved in the tribal courts up in Whatcom County. She has extensive work in child welfare and juvenile justice. She's been on lots of committees, done lots of presentations, lots of publications on both child welfare and juvenile justice. My understanding is, Ryan can shake his head yes or no, but she is a friend of CASA. She does appreciate, yes, very enthusiastic nods from Ryan. So she is aware of what CASA does. She's very supportive of the work that we do. I'm sorry, not CASA, volunteer child advocates, and is very supportive of the work that we do and understands a lot of the work that we do in the system as a whole. Also of note, she is an enrolled member of the Pueblo of Isleta, I would guess, and she's a descendant of the Laguna Indian tribe, both of which are out of New Mexico. So again, that's where her tribal experience comes in as well. She has done also a lot of work specifically with ICWA, obviously, because of her background and her experience in child welfare. All right, and then the other justice that we have who's just been appointed to the bench is Justice G. Helen Whitener. She comes out of Pierce County, where I come out of. So she was on the Pierce County Superior Court bench. I believe she's been a Superior Court judge since 2013. Prior to that, she was on the Board of Industrial Insurance Appeals. So she was an administrative law judge in that realm. She has extensive experience and work in diversity and inclusion and equity. Those are kind of her biggest focuses. The other things that are really highlighted about Justice Whitener is that she's an immigrant. She came to the United States from Trinidad, I believe, when she was in high school. She identifies as LGBTQ and is a very big advocate for that class of people. She also identifies as disabled. I understand she has a back condition, so she identifies with that as well. So she is known to be somewhat of a very socially active justice. Like I said, she does a lot of work with diversity and inclusion. She has not done a rotation at Pierce County Juvenile Court. So like I said, she came to the bench, I believe, 2013. She has not been on a rotation out here. I know that she has sat on a couple of our termination trials that have been assigned to her, but she does not have a lot of experience, in my understanding, with regards to juvenile child welfare systems. So we will see what will happen. They have both been sworn in, so they are now on the bench. Anything that is, I'm not sure exactly what the Supreme Court is currently doing with regards to argument, but any decisions that will be coming out in the future will include their opinions. We're still kind of in the process of rolling over, so the old justices are still you'll see them still signed on to some of the decisions that are coming out. All right, any questions about any of that? I know you guys will interrupt me if you have questions. So, all right, so let's move on to kind of the more meat and potatoes of what we're talking about today, which is going to be the Supreme Court decisions and some Court of Appeals decisions that have come out this year that affect child welfare and the work that we do. I believe there are 9 or 10, something like that, decisions that have come out. I think it's a few more than last year that were coming out, but as I haven't been tracking the trends, it seems like a lot to me. The other thing that is of note is the decisions that we're going to talk about today are what are called published opinions, as opposed to unpublished opinions. So the courts of appeal can issue one or the other. Generally speaking, unpublished opinions are very fact-based, and so the decision is maybe something that's very specific to that set of facts, and so it's not something that is applicable to a wide variety of cases. And so those are considered unpublished opinions, and the courts, attorneys generally cannot cite to those when writing a brief or making an argument. Published opinions, on the other hand, contain some facts or some hypothetical situations that may apply to a broad variety of cases, and so then the court will publish an opinion because the logic may extend beyond just the case that the court is looking at. A lot of dependency cases tend to be unpublished opinions because they are very, very fact-specific cases. All of the ones that we're talking about today, all of the 10 or 11 that we have, are all published opinions. So there is some information in there that could be applied broadly to all of the cases that we are working with. Just a quick reminder, this is what the map of the Court of Appeals looks like. This is from the Court of Appeals website. So depending on what county you're in, that dictates what division will hear your appeal. So Division 1 is King County to the north. Division 2 is Pierce County to the south and west. And then Division 3 is everything on the east side. So each of these three courts of appeal have their own panel. They make their own decisions. What one division says is not necessarily binding on another division. So if a decision comes out of Division 1 up north, that's not necessarily binding on Division 2. There could be a difference in how they handle things. It's called a split in the divisions. More often than not, though, I think they are generally more or less aligned. Of course, once a case goes out of one of the lower courts of appeal and goes up to the Supreme Court covers the entire state. All right, so now we're getting into the cases. How I organize these is they are done in order of when the decisions came out. So you'll see on the side there, I have the name of the case, the date that the issue was, decision was issued, excuse me, and then what division the case came out of. So first here we have the dependency of AETH, came out in August of 2019. This is out of Division 1. It's a case out of Snohomish County. This is the case that I'm sure that everyone is familiar with, but it's the case where the court found that there were some concerns with how the advocate program was operating. Some concerns with the advocate program being under the direction of the Superior Court. I understand now that the advocate program is now under the umbrella of the executive, so as to solve that problem, and they've made a lot of significant changes in that program to alleviate the concerns that the courts identified with regards to that particular case. So the quote here on the side is what the appellate court decided and had some concerns with. And it said the Superior Court, its direct agents, and its own attorneys, all under the supervision of the judges, repeatedly aligned with and literally became a party litigating this case against the parents throughout the case. These circumstances, which existed before, during, and after the termination trial, resulted in a tribunal that was biased and violated both parents' rights to due process and the appearance of fairness doctrine. So there was a significant concern here that some of the actions by the advocate program and by the Superior Court were misaligned with the parents and ultimately violated some of the parents' rights as to due process. So again, I know our program looked at this in depth and came away with some takeaways. We've changed the way that we've done a few things in Snohomish County as well. So this is a great case to look at to find out what concerns the Court of Appeals had and to make sure that your program is in line with what the Court of Appeals says is appropriate for advocate programs to do. All right, next case is the dependency of ZJG. This is from September of 2019, also out of Division 1. It seems for some reason a lot of the cases that Division 1's been pretty active this year, we'll say that. So what happened in this case, I've got my little notes here that are very, very small. But what happened in this case, this has to do with active efforts for an ICWA inquiry at the shelter care hearing, at that initial 72-hour shelter care hearing. So what happened in this case, the social worker had contacted a couple of proposed tribes, and they reported that the grandmother of the children was enrolled, but that the children were not enrolled. So it was possible that ICWA applied, and at the shelter care hearing, there was a discussion about this, and at that time, the court found that there was no reason to know that the children were Indian or that the Indian Child Welfare Act applied. Later on, a tribe actually intervened on behalf of the children, and it was determined that the children were ICWA eligible. And so at that point, the court changed its finding. So instead of saying there was no reason to know that ICWA applied, the court ultimately changed and said, yes, this tribe has intervened, these children are enrollable, we need to do ICWA on this particular case. And so what the court ultimately found is that the court really does need to make an inquiry about ICWA status at that 72-hour shelter care hearing. If the department conducts a good faith investigation into the child's status, the parties elicit the relevant evidence at the hearing, and the court actually considers that evidence before making a ruling at the shelter care hearing, then the court has substantially complied with this particular requirement. Our courts, I know I attend all of the shelter cares in our program, and I know that our courts have really made a concerted effort to make this question more clear when they are conducting a shelter care hearing. The department gives a report about ICWA status. Both of the parents are asked on the record about ICWA status, and the court actually makes a statement that they've heard that evidence and considered it, and then determining whether or not ICWA applies to that particular case. So this is, it's nothing new, it's just reiterating that at every shelter care hearing, this is something that needs to be discussed. And the department really needs to make a good faith effort to determine, with the information they have at that time, whether or not the children are ICWA eligible. All right, next case is the welfare of AALC. This is November 26, 2019. This is out of Division 2. I believe this is a Kitsap County case, if I am not mistaken. But again, it's another ICWA case. This one has to do with active efforts for ICWA, for the Indian Child Welfare Act. So what happened in this particular case is the children were actually enrolled in a tribe. And after the disposition hearing, the court identified a number of services for the dad to engage in. But then there were some problems. There was a several-month delay between when the court actually ordered the services at the disposition and the department provided access to those services or referrals for most of those court-ordered services. So there was a 6-week delay between the disposition order and when the referral for the domestic violence assessment actually went out. And then actually once the referral for the DV class went out, it was a 12-week program and they were already 4 weeks in, and they said, no, you have to wait until the next cycle. So he would have to wait another 8 weeks. So there was a delay there. There was also an issue with housing, was an identified parental issue in this particular case, and there was no information in the record that the department helped with finding housing resources for the dad. So what the court ultimately found was that the Court of Appeals ultimately found that the department's work on this particular case was not active efforts, which are required by ICWA. And if you look up at the top there, the top couple of bullet points, Federal Indian Child Welfare Act requires affirmative, active, thorough, and timely efforts to provide services, including identification of community resources related to housing. And then the Washington Indian Child Welfare Act requires timely and diligent efforts to provide or procure services. So what ultimately happened here was the court found that the children, everyone knew from the onset that the children were ICWA eligible, were enrolled in a tribe or enrollable, but the department wasn't timely in providing services, wasn't active or thorough in following up on those services, and the court ultimately found that it wasn't active efforts, and that the department needed to do more for this ICWA family. All right, the dependency of AMS is from December of 2016, Division 1, again. So in this case, there was a physical abuse allegation, and law enforcement was actively investigating the parents, I believe the father, for this particular incident regarding the physical abuse. The department requested that as part of the services for the father that he undergo a psychological evaluation. The father's attorney requested that in order as part of a contingency to complete the psychological evaluation, again with this pending law enforcement investigation, father wanted what was called the Decker order. It comes from a case called State versus Decker, which is basically allowing that any information that is revealed in an assessment or an evaluation cannot be used to further prosecute a criminal case. So if in the course of the psychological evaluation, dad revealed some information that was detrimental to his criminal case, that information could not be used in the criminal case if it came independently from that psychological evaluation. We deal with this actually, I think, on an increasing frequency. We get a lot of requests for Decker orders. What the issue was in this particular case, in the AMS case, is that most of the time, if not always, the prosecuting attorney needs to be involved in that conversation, because obviously they would be the ones who would be charging any sort of criminal case. And so they have to agree to the issuance of a Decker order and saying that, you know, we won't use any of the information contained in this psychological evaluation to further pursue the charges against the parent. What the court ultimately found in this case is that there's a very, very big discussion that gets very legally complex about the different types of immunity. But what the court ultimately found is that the trial court doesn't have authority to grant immunity under Decker over the objection of a prosecutor. So if a prosecutor agrees, probably not a problem, but if a prosecutor says, no, I won't agree to this immunity, then the trial court doesn't have any authority to grant it. That being said, there is another statute, which is up there, it's RCW 2644-0532, which does allow a court to grant limited immunity to parents who participate in psychological evaluations and dependency proceedings. So it seems like that would cover it, although the court did identify that that statute alone may not be enough to protect a parent's Fifth Amendment rights against self-incrimination. And so what the court advised is that it may be appropriate for a trial court to rely on that statute, but then further craft a protective order that gives even more protection to the parent's rights, all within the dependency context. So it wouldn't involve the prosecutor's office necessarily, but would basically provide some additional protection so that parents do feel able to engage in that psychological assessment to help further the services in the dependency case without infringing upon their rights against self-incrimination. Okay, so now we're moving into the cases from 2020. This is one of the big Supreme Court cases that we had this year. So this is the one that I was referring to earlier, where there was that change in statute regarding mandatory reporting and the duty to investigate by DCYF. So what happened in this case is a child was brought into care, into the department's care. Dad was residing in Idaho. Mom was in Washington, dad was in Idaho. The department moved the child at dad's request to dad in Idaho. So I don't believe there was an ICPC. It was early in the case, but they did go ahead and move the child over to Idaho. At some point, it sounds like there may have been some reports before he was moved and then also some conversations afterwards. But mom reported to the department that the father in Idaho had a criminal history. He had a history of domestic violence against her. He had a history of alcohol abuse, and that there had been a no contact order between mom and dad at some point previously. And she described in detail some of the significant abuse that she endured from the father. Mom told the department social worker something to the effect of, if the child is placed in Idaho with dad, he will be dead in 6 months. Unfortunately, dad did strike the child in Idaho, and the child died after he was there for 3 months in Idaho. And so what happened was the mother and the estate of the child sued the department and said, when mom reported to the department this history of domestic violence, criminal history, things like that, that triggered a duty for the department to investigate. The court ultimately said, no, that's not entirely correct. The holding of the court is there on the right side, and it says a report predicting future abuse absent evidence of current or past conduct of abuse or neglect does not invoke the duty to investigate under the previous RCW that handles this particular issue. So what happened here was the history of abuse was not particular to the child, it was particular to the domestic violence between mom and dad. And so the court said, you know, mom's reporting that this child is not going to be safe there, that the child will be deceased in 6 months, is a report predicting future abuse without the evidence of current or past conduct of abuse or neglect of the child. So ultimately, the court said that the duty to investigate was not triggered by DCYF in this particular case. And I think this is why there was that nuance change in the statute that we mentioned earlier, where you have to have a specific allegation as opposed to a possible occurrence of. I think they were trying to clean up that language a little bit as a result of this particular case. All right, moving along. So the parental rights of DJS, this is January 2020, out of Division 2. And in this particular case, again, we have another ICWA active efforts case. The child in this particular case was eligible for enrollment. And in this particular case, one of the issues was sobriety. And what happened was the court delayed the parenting education program until sobriety wasn't an issue anymore. So a lot of times we will have providers who won't see a parent until they have documented 30 days of sobriety or something like that. The court in this case found that that was problematic because that wasn't in the court order specifically. It just said that they would offer this parenting education course. It didn't say anything about it being contingent upon sobriety. And so the court found that because dad ultimately did not maintain a period of sobriety sufficient to engage in the parenting education program, the court found that the department hadn't offered him that particular service. So again, the court reiterated that under ICWA, department has to provide all services ordered and all necessary services reasonably available. Again, this is a termination case. Where it says parental rights, that means we're talking about a termination at this point. So the court found that the department hadn't offered all of the services reasonably available to remedy the parental deficiencies. Again, reiterating that both ICWA and the Washington State ICWA requires active efforts to provide services to prevent the breakup of a Native American family. And active efforts, we talked about it on one of the previous slides, but it means more than just making referrals. The court is supposed to enter a finding as to whether doing active efforts under ICWA would have prevented termination or would have been futile. The court didn't in this case, so that's another issue that courts need to address for ICWA cases on termination, is whether or not those active efforts would have actually made a difference in the case of the Indian family that you are particularly working with. Okay, so next up we have the dependency of SMM. This case came out in February from King County, Division 1. So what happened in this case, the kids were appointed a volunteer advocate initially at the very beginning of the case. At some point, fairly quickly, I think, after the case had commenced, the children were returned home to the parents. And so they were with the parents for a time, and then something happened and the children were removed from the parents' home. When the children were removed, the court did not appoint a volunteer advocate for the children. So there was, advocate had been on the case, had withdrawn when they were home, and when the motion to amend placement, the court did not appoint a volunteer or a GAL. Was in the best interest of the child. So what the court found in that case is that the Court also didn't make a finding whether there was good cause to not appoint a GAL or a child advocate. That's in the statute, is the court must appoint an advocate or a GAL unless there is good cause not to. Good cause may be that the child is represented by an attorney. That's one of the options that the statute gives. So in this case, the court didn't make a good cause finding and the court didn't appoint anyone. And this Court of Appeals said that's a problem. The statute says you need to have someone on this case, particularly when there is an issue such as moving a child from a home. There needs to be a best interest advocate at that time. The other note that the court made is that general designation of a CASA program or a volunteer advocate program that doesn't result in any actual representation of the child's interest is not sufficient. So our program, I know that we actually name the person in the order appointing. I know some programs don't do that. Some programs designate the program itself. That's okay as long as there's actual representation of the child's interests. If you just designate a program and then no one in the program is actually checking up on the child, that's problematic. So the court basically found that the court must either appoint a specific advocate or a guardian ad litem, or make a finding of a good cause not to appoint someone. So this is a case that really, again, solidified the value that the courts find with what our advocates do, and reminding everyone that we need to be appointed to these cases, particularly when there are big issues like this at stake that need a best interest advocacy position.
Can I ask a question?
Sure.
And I think you just answered it. I was talking to Ryan about this earlier because I learned that our program has been, I think, filing some of these incorrectly for a long time. So I just want to repeat what I think I heard you say is if we don't have a particular advocate to assign at shelter care, we can just place our program as the assigned, or would it be better to pick one of the program coordinator names to be assigned?
Yeah, I think it's really a program preference. Really, you can designate an entire program as long as it results that someone is there actually representing the child's best interests. So I think if it's easier for your program to do it that way, rather than having to file a couple of, replacement notices of appearances or orders appointing someone, I think as long as you make sure that there actually is someone who is checking on the children and reporting to the court as to what's in the children's best interests, that's the real thing. I think the easiest way to do it is to actually assign someone, because then you know who's accountable for that. But I think the court does give some room here, whereas if your program cannot do that, as long as you can get the program appointed and then actually make sure that someone is fulfilling the requirements of the statute, that should be acceptable to the court.
Okay, and since we only have 2 program coordinators, then we might just pick. Yeah. The other thing that's noteworthy is this is at a Division I Court of Appeals, so that's over on that's the King County North. So it's not necessarily binding on you guys over on the east side, but obviously, sometimes when they come up with stuff, it kind of gives us a hint as to what best practices should be. And your court, if this issue came up in your court, they may require the same. But I think the real critical piece here is making sure that there is actually a physical person who is checking in on the kids and reporting to the court what's in the children's best interest. All right, let's hop on over to the dependency of EJM. This is from February of this year. Again, Division I, this is King County. This is actually, you may remember the case of the Sky Metawalla who disappeared out of Bellevue. I think it was 8 years ago or so now. This case actually is a sibling of his, a half sibling. It involved his mother. What happened in this particular case is the child, I believe, was under the age of 12. King County generally appoints children at the age of 12. This was a young child. I want to say she was maybe 2 or 3. And grandmother, maternal grandmother, actually hired an attorney for the child. That attorney put in a notice of appearance, and then that attorney filed a motion to amend placement. And there was some concerns because the attorney just appeared as retained by the grandmother. The attorney had not been appointed by the court. The court had not appointed, or no one had requested an attorney for the child, and the court hadn't actually appointed anybody. The attorney just was hired and appeared on the case. So the Court of Appeals found this was problematic. The Court of Appeals noted that 1334-107, which has to do with the appointment of counsel, applies to both privately retained counsel and publicly funded counsel. However, counsel must first be appointed by the child by the trial court. So what the court decided was that an attorney cannot just appear in a case on behalf of a child without being appointed by the court. There has to be that court appointment first. The court found that the legislature really wanted to ensure that attorneys representing children are trained in dependency issues. This is a very unique area of the law, and they want to make sure that the attorneys that represent kids know what they're doing and are subject to the court's oversight. So the court essentially said that private counsel, publicly funded counsel can't just appear on a case. There has to be an official order appointing counsel done by the court. And then at that point, it would be determined if it would be a private counsel or if it would be a counsel at public expense for the child. Okay, welfare of TP. This was a February case out of Division 2. This was a Pierce County case. This has certainly changed the way that we do some things in Pierce County. So what happened in this particular case is there was the initial shelter care hearing, and the parents, both of the parents at the initial shelter care hearing requested a contested shelter care hearing. At the time, our practice in Pierce County was to set a shelter care hearing on one of our contested dockets, which get full. And so we had to set it out a period of time. In this particular case, it was over the Christmas and New Year's time span of the year. And so when the parents requested a contested shelter care hearing, the court said the earliest date that we can do it is January 2nd. The problem is that was 22 days after the initial shelter care hearing. Ultimately, the parents agreed to shelter care, so there wasn't a shelter care hearing. In that interim, they had ended up agreeing. But 1334-0651A requires a shelter care hearing be held within 72 hours after the child was removed in the absence of a request from the parents. The shelter care hearing may be continued only when, for good cause, a parent is unable to attend the hearing and only upon a parent's request. So one thing to note is this isn't if the parent's attorney is not available, it's if the parent is not available. And then when the parent makes such a request, the hearing has to be scheduled within 72 hours. So what this has done in our practice in Pierce County is a couple of things. I've noticed that our judges, if there is a request for continuance, our judges really have a colloquy with the parents. They really have a conversation with the parents about understanding, you have a right to this hearing today. Are you requesting this new date? Why do you want this new date? They ask them very the other thing that that we notice is that when we are going to have a contested hearing, we usually do it right then and there. If the parents are requesting a contested hearing, the department is ready to proceed. Usually it's, we don't have a lot of witnesses, don't have a lot of documents, but we move forward on a contested hearing immediately at that time if the parents are requesting that. So again, this is another just kind of an underlining by the courts that say when the statute says it has to be within 72 hours, we mean it has to be within 72 hours. And there's some very specific parameters when you can divert from that requirement. Okay, ANG is the next. So this case was, I believe this in Bellingham. So what happened was the judge who was assigned to hear the termination case was formerly an assistant attorney general, and turns out he had done dependency work, and he had actually been the prosecuting AAG for a couple of mom's prior termination trials. So the judge had previously handled those terminations on behalf of the department. What happened was he then at some point in between when he was the AAG and when he was the judge, he had done a different role. But essentially, when these prior terminations had happened, he was the AAG who had handled the case. The judge told the attorneys in the case that he recognized mom's name and that he had been involved in the prior cases. But mom wasn't in the room when that happened, and there was no indication that the attorney raised that, or that the judge raised this issue to mom directly, or that mom's attorney raised it to her. It sounds like there was a conversation had before court started. No one thought it was a problem, but then no one actually told mom. So what the court ultimately found out is that mom's due process rights were violated when the judge failed to recuse himself from the termination trial when he had previously been the AAG seeking termination of her rights in the prior dependencies. Had mom been told and had agreed to it, it wouldn't have been a problem, but she hadn't been given that opportunity. And so there was a conflict of interest there. And the court found that that was problematic and sent the termination back. So again, this is one that's kind of a very fact specific, but as some of our AAG colleagues take on other roles, something to be noted of. And again, if a discussion had been had with mom and she had said, yes, I'm fine going forward with this judge, wouldn't have been an issue. All right, I've got one more case for you to talk about. I know I talk fast, so we're moving pretty quick. But this is the case of WWS. This came out at the end of March from Division 1. There were a number of this kind of number of random decisions or mandates that have come out of this one. So ultimately, a couple of things that are noteworthy is the department in this case had requested that mom participate in UAs. But there was no evidence on the record that mom had a substance abuse issue. So the court ultimately decided that the trial court had abused its discretion when it requested that mom do the UAs absent evidence that would identify substance abuse problem, because there was no evidence of that otherwise. There was also some personal conflict between the social worker and the parent, the mom that was involved in this case, not unlike many of the cases that I'm sure that we all see. But mom and the social worker did not get along, and there was at some point a request for the department to reassign the case. Mom's attorney actually asked the court to order the department to assign a new social worker to the case. The trial court or the appellate court found that the trial court lacked the authority to do that. The court couldn't order the department to assign a new social worker. That has to do with the separation of powers. But essentially the trial court can't order a new social worker. The other issue that popped up in this case is on appeal. There was the guardian ad litem's office requested some additional time to file a brief on the appeal. The court actually declined, as best as I understand it, declined to offer that extension and made some commentary about the role of the guardian ad litem in an appeal. And those bullet points are noted there, but they stated that a guardian ad litem has party-like rights in superior court and can seek review in an appellate court to enforce those rights. However, a guardian ad litem is not a party entitled to file a merits brief in response to a parent's appeal from a dependency order. So what the court basically says here is that we have a lot of party-like rights, but that party-like rights do not necessarily extend to us filing a brief as a party in an appellate court. Appellate courts very, very often will review briefs from other individuals who have an interest in the case. Usually it's called an amicus brief or a friend of the court brief. So this doesn't exclude that the guardian ad litem's office has an opportunity to file something. It's just how the courts are going to handle it, whether they're going to handle them actually as a party, or if they're going to be considering them as more of a friend of the court to provide additional information to the court. In my time at Pierce County, we've participated in one appeal, and we had a similar outcome from our case. We requested both to file an appeal and then also to participate in oral argument. Our appellate court, Division 2, asked the mother's attorney and the department for briefing on whether or not we should be considered a party to the case and be authorized to
file a brief and to participate. They both supported us and said, yes, we did. The court said, you know, we recognize that you have party-like rights. We're not going to identify you as a party, but we are going to allow you to participate in this appeal, both by filing a brief and then participating in oral argument. So it seems like what Division 2 is doing here is kind of consistent with what we've seen, or what Division 1 is doing in this case, kind of consistent with what we've seen in Division 2. I do know that King County is very active in their appellate work. I haven't had an opportunity to speak with them about if this is going to change how they approach their appeals. But I know that they traditionally do file and participate in a lot of appeals. So I will be interested to see how they continue to advocate at the appellate level for their particular cases.
Morgan?
Yes.
Would that also apply to the child, since they're not a party either?
The court didn't mention that. That's a good question. You know, that's a really good question. The citations that the court specifically discussed when identifying the GAL as having a party-like status were specific to the guardian ad litem. I haven't done enough research to know the case law surrounding the, you know, whether a child is considered a party or not and in what circumstances. I would imagine that the same kind of logic could apply, and they could say that the child is not necessarily a party but has party-like rights. And then I think it would potentially be on a case-by-case basis whether or not the court is willing to consider a briefing or oral argument. I would think that the court would want to hear from a child who has a serious position on an appeal. So I would be hard pressed to find an appellate court that would deny the child a right to participate in an appeal. But this is it's pretty broad the way that they've painted this, and I think you could make the argument that the same logic applies. Although I think it's absolutely relevant that both the guardian ad litem and the child have important information for the appellate courts to consider. So that is what I have for you today. My contact information is up there, both my email and my phone number. But I'm happy to work with Ryan right now to facilitate a discussion if you have any cases about, or any questions about any specific cases, or concerns about anything, or all of the above. No, easy enough. All right, so like we said, we're going to put together this PowerPoint, and then I'll put together the cases as well. If you start delving into things through those cases or through this PowerPoint and you have questions or you need clarification on something, please feel free to reach out to me. I'm happy to answer questions that you have. Ultimately, I guess this will be up on YouTube or something as well. I did just see that we have, oh, there's just some chats there thanking me for doing this. So just want to make sure I wasn't missing any questions or anything that anyone had. All right, so we will get some resources for you guys, but like I said, feel free to reach out if you have any questions. If you dive deep into one of those cases and want to talk about it, you know how to get a hold of me.
Thanks so much, Morgan.
Yeah. All right. Have a good day, everybody. Hope everybody's hanging in there.